First off, I just saw up here, there's a big sign that says wrap it up. So if somebody right down here wants to hold on to that and let us know when we got to get out of here, we'll give it to Jules. As said, my name is John Cox, and I'm Assistant State's Attorney in Baltimore County. He didn't get the sign. We're going to conduct basically a live social experiment here, and that is whether or not a person that has been described by many as a fairly aggressive prosecutor and a defense attorney who's been described by the Baltimore Sun as a pit bull can get along for a half hour to 45 minutes. I was challenged by people in my office to see how long I could go without Michelle talking, but I'm going to abandon that one too. Frankly, we want to handle this as a back and forth because you're going to hear that we worked together on a case that had important results and got along perfectly during the course of all of that. And it's obviously our intent to try to address that. I was going to say until the first session this afternoon that it didn't look like that was going to be an issue. Everybody else encouraging people to just get along. But it is something that is obviously, at least in my mind, and I know Michelle's mind, very important and very productive for the right result. I'm going to take just a few minutes before I let Michelle in, just to tell you a little bit about the Bernard Webster case itself and in addressing the evidence that was available. It was 4 years before I was in the office. I came to the Baltimore County State's Attorney's Office in 1986. But 4 years before that, on the 6th of July, and I got to tell you, these lights in my eyes are driving me crazy, but I guess the camera's going. The 6th of July of 1982, a 47-year-old woman who was a school teacher had been out sunbathing outside of her apartment, came back into her apartment, and no one else was home. The apartment itself was a complex that had a outside door that required you to be buzzed in. So there was at least a small amount of security available to her. But she went inside of her apartment and into her bedroom, and out of her closet came a African-American male who assaulted her. He gave her the impression that he had a gun to her back. She felt a hard object to her back, and she was raped in her bedroom. And without giving any of the details of that, she did have some opportunity to see the person that had sexually assaulted her. He then made his departure. She remained in her room until her husband arrived shortly thereafter, and the police were obviously called. One of the things that was discovered, which was a little bit unusual, was a pair of pants that didn't belong to the victim or her husband. It appeared, and I think everybody would agree, that those pair of pants had been on the rapist at some point. He left in a pair of gym shorts, and the pants were left literally lying on the bed where she had been raped. Inside of those pants were 3 keys. They later discovered one key was to her apartment door and had been inside the apartment, so he'd been around and rooted through things. Another was to the mailbox key for her mailbox, which had also been in the apartment. The other was a key that had no relation to her at all. The police, in investigating, found several employees at the apartment complex who described a person that they had seen just outside the building, appearing to try to get in by one employee, and then the manager saw this person inside the building near the apartment of the victim. Both of them gave descriptions. The police, in investigating, looked at an individual who had been caught a couple of months before in a office building in Towson, about a mile away from where this rape occurred, had been caught stealing a purse and had been convicted of that. They put his picture, that was Bernard Webster, they put his picture in a photo array or a photo lineup, showed it to the employee that saw the person outside the building, and he picked Bernard Webster out as the person that he saw. Showed it also to the woman, the manager, who had seen him inside of the building, and she picked him out as could be or possibly out of the other 6 that were available, or the other 5 that were available to her. Bernard Webster was arrested. Bernard Webster was put in a live or physical lineup and was identified by the victim as her rapist and identified by the female manager who had seen him inside of the building. The most bizarre part of this that many of us have no ability to explain, the extra key that was found inside that pair of pants was then taken to a place where he had been residing and worked on one of the deadbolts, or appeared to work it. They said he had to jiggle it a little bit. It worked on the inside part of the deadbolt, not on the outside part of the deadbolt. Mr. Webster was obviously prosecuted, and he was convicted. He was sentenced to 30 years to the Division of Corrections. I became aware of Bernard Webster only through a reported appellate case, at least at that time. There ended up being a reported appellate case that dealt with an issue concerning the lineup, where it frankly was addressing more Sixth Amendment issue of right to counsel, where the Public Defender's Office had provided, I don't know if it was a law clerk or a law student.
Wasn't a lawyer.
Wasn't a lawyer, is the bottom line, to be present at the time that the lineup occurred rather than an actual lawyer. That had been one of the appellate issues. But the bottom line is his conviction was affirmed. And now I'm going to hand it over to Michelle for the next step in the process.
I just have to say that in many respects this case is very sobering because contrary to I think what my client believes, when I read the transcript, I found the evidence quite overwhelming. I know enough about the vagaries of eyewitness identification that the eyewitness identifications I found could very well be explicable and consistent with innocence. The biggest problem I had was the fact that there was this business of the rapist who leaves his pants at the scene and then also leaves in the pants a key, which the trial testimony, when you read it, it wasn't simply that testimony was presented that the police investigating officer had gone down and managed to open the door with this key. There was actually, to this day, I don't know why this was presented, but there was testimony presented by a defense investigator that he had also gone down to this building and had jiggled this thing and gotten the key. The long and short of the key thing is that the truth is the lock was broken. And any key or any device, probably if you jiggled it enough, would have opened that door. But what is most sobering about it is that you can read a transcript and be left with an incredibly, as it turns out, completely mistaken impression about the overwhelming nature of the evidence. And it's rather chilling because when you read appellate opinions, we hear over and over and over again about the need to not grant relief in light of how overwhelming the evidence is. I received several sort of very short, to the point, simple pleas from Bernard Webster to try and test this evidence. And I can't even really explain why I found his, I mean, frankly, at that point, we didn't have that many cases. Our state had only, within the last year, passed a post-conviction DNA testing statute, and unlike my office today, which is cluttered with hundreds of requests, really didn't have that many. It's not clear to me right now if he would have necessarily made the cut based just purely on an evaluation of the transcript. I did make some phone calls. I found out that the police no longer had possession of any of the physical evidence in the case. Interestingly enough, there was one hospital in the state of Maryland, the only one, to my knowledge, that had been conducting forensic sexual assault examinations for many years, but actually maintained and cataloged slides taken from every sexual assault examination that had been conducted for, I think, a period of 20 years.
Since 1977.
Yes, and there's a sort of sequel to this story that I'm about to tell you that I only found out this morning from John, and apparently I'm going to have a whole wing of the Division of Correction dedicated to me, because apparently as a result of the emergence of this information that GBMC had stored these slides, there have been, what, 54?
54 cleared rapes as a result of evidence that we've gotten from those slides. We frankly, I can tell you, didn't know that the evidence was there. And 37 arrests, and the reason there's a difference between the 54 and the 37 is because some of those were serial rapists. We had one, and I can't tell you the exact number, but I think at least 10 rapes by one individual between 1978 and the year 2000 that we've been able to discover after learning that these slides were at this hospital.
So I don't know whether you call that the law of unintended or indirect consequences, but that's how that turned out. GBMC had preserved it, and they had actually preserved it properly. There are other hospitals in Maryland that do keep these slides, not for as long as GBMC had has done typically for a long time. But they often don't use a staining technique that's conducive to properly preserving the sample. GBMC had the good fortune to actually have a pathologist who had a lot of interest in forensic issues. And anyway, the long and short of it is that the slide produced a full, I don't know at the time whether it was 12 or 16 marker profile, but it was 13, yeah. But it was a full single source profile. And what I guess I'd like to talk about in terms of, it's a little bit ironic, as you may have noted, John, it's actually steely-eyed pit bull. It's not just pit bull. Okay. But it is a little ironic to find myself up here talking about the virtues of harmony and cooperation, because I don't think in some ways that's necessarily my reputation. But the truth is, getting to the truth does often require some humility, and it requires humility sometimes as a precondition for cooperation. From my perspective, and I won't let John talk about what I either did or didn't do that facilitated the process, but from my perspective, transparency and the willingness to act quickly and expeditiously were the critical things that made this work. And when I say made it work, what I mean by that is we were able to resolve the issue, to exchange the relevant information, and to stay calm and civil and deal with a press extravaganza beyond anything I had ever had to cope with in my professional life. And we did this for the benefit of a client who got out of prison quickly once John had satisfied himself that the evidence reflected that he was not the rapist. Now, when I say expedited, what I mean by that is, and part of expediting that also requires transparency it required transparency on my end. I drove up to John's office the underlying data for the DNA tests. This is not you have to be willing, I think, to be completely open about everything that you have. I made all of those materials available to him. Understandably, maybe you want to talk about the process of, because we've heard a little bit of an allusion to this earlier today, the difference between exculpatory versus exonerative evidence. This case, I think, is a pretty good example of that. I mean, what we have is a single source profile, and it's not Bernard Webster's. Okay.
Right. A little bit of background right before that. Bernard Webster had filed his own petition for post-conviction relief in 2001, and it was very vague and not very helpful. It did say there was evidence that hasn't been tested that he wants tested.
I think it said he was innocent, too. Yeah,
it did. Yeah. That's very vague. And it was a routine post-conviction filed by an inmate from the Division of Corrections that we answered in a routine way, in effect alleging this is not an adequate basis for post-conviction relief.
File G.
Yeah. And so it was being treated in that way. Michelle had become involved, had filed the motion for the DNA testing. Actually, I think right before our post-conviction DNA statute went into effect. It had been passed by the legislature, but was not yet in effect, and frankly, I was not very aware of it. And it was before even the higher people in our office were aware of it either. There was a very junior assistant was assigned to the post-conviction, and there was an order signed by one of our judges directing the DNA testing be done. The only piece I can say in hindsight that I semi-regret was just that part of it, and I know that the statutes are much clearer and everybody can act as they deem fit, but the only very slight regret was that it went to the lab of Michelle's choice, just because we weren't really involved that much when the order was first signed, and that ended up being, I think, a lab out in California, if my memory serves, that I didn't know of, and it created a future problem for me because we haven't told you this part, but we caught the real rapist shortly after we released Mr. Webster. And then I had another issue in terms of chain of custody and another piece in all of this in terms of my proving the case against the actual rapist. But the bottom line was that when Michelle came to us, the slides were sent out to the lab that she had chosen and was ordered. When she came to us with the results, we certainly were going to take action to make sure that this was right. Another side piece that I'll address, if time permits, was dealing and trying to explain all this to the victim of this case, who was at that point now 67 years old. But it was certainly our desire to make sure that we had something that was accurate, because certainly the evidence looked like Bernard Webster had committed this crime. All that had been tested was for the presence of the DNA of Bernard Webster. We were not completely aware of all the security procedures or the reliability of the slides and making sure they were in fact slides taken from this victim. So part of it was that I went to the victim and asked if she'd be willing to give us a DNA sample, because as you heard, all of the evidence from the police department was no longer there. We also asked her husband to give us a DNA sample. We also received permission from Michelle, I think with Michelle's presence or at least someone's presence, to go to the Division of Corrections and get a DNA sample from Bernard Webster that we can witness came from him. That was then tested. If my memory serves, we got all of that by about mid-October of 2002. And it was certainly our desire and believing that he could be an innocent man to make sure that was done as quickly as possible. October 31st of 2002, we had the results. And it was not Bernard Webster. And it was not her husband. And it was her slides. Her DNA was found on those slides. Called Michelle and said, I want him in here as fast as we can get him here. And that's what happened. We had him there within the week, and that's frankly just a transportation issue with the Division of Corrections, and getting him here and did what was right. I think if my memory serves, Michelle can confirm if I'm wrong here, or correct me if I'm wrong, I think we kind of cheated our way through it. The statutes at that time didn't really exist to get the right remedy as quickly as we could do. And if I recall correctly, I basically, in effect, directed her to make a motion for a new trial. I've never said I directed Michelle to do anything. But I suggested that she do a motion for a new trial that was not going to be timely under the rules as I understood, and we would just not object to its lack of timeliness, and conceded in the motion on the spot, and then it was set back in for trial, and within the next minute I dropped the case. So he was released right from that spot. I don't know if I'm stepping back into Michelle's category, but just on a factual recounting, we put that DNA into the CODIS system, and within, I think, 5 days, we were notified of the actual rapist. And the DNA hit. We had him arrested within 2 weeks after that. About less than a year later, he actually pled guilty to a first-degree rape and was sentenced to 20 years to the Division of Corrections. Back to you.
Yeah, and actually we were talking about this morning. I have, just for purposes of my own intellectual curiosity and to just sort of try and put all the pieces together in the Webster case, I've been trying to get a photograph of the individual who was the actual perpetrator. We have a photograph of him when he was 40 some odd, when he was ultimately arrested, but I've always been just curious to see what he looked, because the photograph that's available from my perspective really looks nothing like Bernard Webster. Very different facial features. But I haven't been able, never succeeded in doing this, but I would be very curious to see what he looked like 20 years earlier. I think one other aspect of this, and it's not always the case, but it often is the case with exonerations, and particularly DNA exonerations, that they often become a media event, and in fact they can become kind of a media spectacle. Another one of the sort of ironic unintended consequences of how quickly this case moved once the state had satisfied itself that these results were accurate and were probative of Bernard's innocence, is that I was not able to, because of problems in the bureaucracy of getting into the Division of Correction, I was not able to go out and tell him what was happening. I think I ended up having a very clipped, brief conversation with him as the guard was coming down and telling him to pack his things up. And he didn't know if he was packing his things up because they were moving him to a different prison. He didn't know what was going on, and he was, as you can imagine, a little bit paranoid at that point. So I was really quite concerned if a police car from Baltimore County pulled up that there was going to be a bad scene. But he the day that he walked out of the courthouse, he had no jacket, he had nowhere to live, he had nowhere to go, and within 5 minutes he was, and I'm really not exaggerating, literally almost assaulted by a media television reporter who was insisting that he make some on-the-record comment, which he did, but apparently it wasn't long enough or loquacious enough for the reporter, who proceeded to sort of like start shoving him up against the wall. One of my colleagues moved to intervene, and the next thing you know, it was almost a fist fight breaking out, and my client ended up hiding behind the bushes in a coffee shop across the street because the car I thought I had arranged to pick him up so he could just get him out and get him in this car. That didn't work out. And I remember thinking, I had done some high-profile cases in my career, but I remember looking out into that courtyard and seeing this bank of TV cameras and reporters and this fight breaking out, and the next thing I know, finding out that my client is hiding behind the bushes asking random people for a cigarette because he's kind of stressed out, and thinking, you know, I don't know a lot about the media, but I know this isn't how it's supposed to be going. Fortunately, I learned another thing about the media, which is, you know, they don't put that kind of stuff on the 6 o'clock news because they don't look so great when they're, you know, having a fist fight with a person who's the subject of their news coverage. But the media dynamic does potentially create, it creates both problems and peril for, at least in the case of Bernard. It's very difficult. I mean, just the simple fact of someone who's coming out of being incarcerated for 20 years, many people who have been in that situation have a high sensitivity to people using, you know, moving in on their personal space. And just the prospect of reintegrating yourself into society when you've been incarcerated for 20 years is difficult enough without having this sort of constant issue of reporters following. And it has a very distorting effect on people's sort of sense of reality at that point. And that, I would have to say, this doesn't have anything to do with, maybe doesn't even have anything to do with a topic here, but that was a whole part of this experience that I was really, frankly, pretty unprepared for. And I don't know what kind of effect or role the media piece of this played for you, but it was a huge part of the experience for my client.
I guess it's just as a side note on the media issue, and then I want to get to a little anecdotal story concerning the victim. Our office had been through an extremely high-profile case of an exoneration before this, so at least we had, I guess to say, some experience of a person who'd been convicted of murder twice, the first time sentenced to death, who was exonerated by DNA, and it got a lot of attention. So we had at least some sensitivity to that point of trying to deal with the issues, and it's not one. We avoided stepping out anywhere near the outside of the building while Bernard Webster was leaving. And not in any way trying to get in the middle of any of that, but did our best, I hope our best, to try to explain that we were doing what we believed to be the right thing and doing the right thing as quickly as possible. One of the things, just to change subjects, that came up earlier, and probably just a slight regret also, but I think things generally worked out, was, and this was a situation of first impression for me, so I had to deal with that, and that was, number one, when to let the victim know that any of this was going on. We now have mandatory notifications for people who request victims of crime, but that didn't exist at the time that she was raped back in 1982. And to be perfectly honest, it was probably a hope or a belief that there was not going to be an issue here. So she was not really in the loop immediately when the post-conviction process started. But once we were notified of the results that Michelle had gotten from the first analysis of the DNA, that was unquestionably the most memorable and most difficult part of my involvement in this entire process. As I said, she was then 67 years of age. Now, I had never met this woman before. I was not the person that had originally prosecuted the case. And so to make that phone call, and my hope was to say, just to tell her who I was and that I wanted to come see her. And understandably, she had no desire to see me unless she knew what it was about. And so that was an incredibly awkward phone conversation to try to avoid telling her what was going on without an ability to be in her presence. And so I had to at least tell her some information, that some question has come up concerning the identity of the person who committed the crime. And she finally agreed to let me come see her. I guess a slight regret is I should have brought somebody with me, although there wasn't anything really adverse that happened, but it was, I'm less adept at dealing with personal issues than many of the people that work in our victim witness portion of our office. So I really probably could have used some help in that regard. But just anecdotally, it's something that I think those of you who are prosecutors out there or criminal investigators who may be called upon to do something of that nature, that's a very significant piece or responsibility to try to handle as delicately as you can, but as forthrightly and as honestly as you can. And the first meeting was just concerning the issue about what we received from the information that Michelle had given us, and certainly nothing that was certain yet, at least in terms of what we were going to do at that point. I can tell you that by my experience with this particular victim, and understandably, at least in my mind, it's a very difficult thing to say that to know in her mind that she had picked this person out of a lineup and that she had said that's the person that raped me, and to try to bear that burden of then being responsible. And obviously we heard some about that this morning. It was very difficult for her to accept that. And then when we had the confirmed results in that next meeting, I can tell you that at least in my mind, she still did not. And it presented an interesting issue for my prosecution of the actual rapist. We never got there because he pled guilty. But in giving thought to how I'm going to prosecute this case, when at least I believed at that time that she still thought Bernard Webster was the person that raped her. To me, the final, closure's not the right word, but the final convincing piece, I think, was when Darren Powell actually pled guilty to committing the rape. And another just interesting side note was that she contacted me after, and she had some time to think, and had written a letter to Bernard Webster, which was incredibly appropriate, and it dealt with the pain that in effect she's feeling with what had happened, and asked me to get that delivered, and of course I did that. But that's just as a word out to all of you. It's something that, and I'm sure that all of you are sensitive enough to deal with it on your own, but just keep in mind that that's something that is very difficult to deal with and try to handle during the course of a case like this. And we're welcome to questions.
Yeah, I think it kind of covers it, so maybe, yeah, if you want to, anyone has questions, be happy to answer.
Any person have a question or comment who'd like to step up to the microphone and give it to us? While I wait to see that, and then otherwise we'll start towards wrapping up. I have one question to the both of you. Was this collaboration a one-time deal, or did it grow out of a relationship?
Well, it just worked for a half hour.
I don't know. I don't mean this collaboration, but the collaboration that you've talked about on this case. Was there already sort of a process? Was this a one-time thing? Did this begin what can be a process?
Well, I don't think there was a process, which I think is part of what, no, and I don't think there was. In the sense of any kind of formal protocol or even, I can't speak to that, John, whether it had even been vetted within your office about how to, but no, I think both of us, to a certain extent, were kind of making this up as we went along.
That's exactly right. And I guess, maybe the question is will it ever happen again? And it certainly will. I share, I think the gentleman's name was Clark, I share some of the concerns about some people in dealing with. I can say that I know by this experience and past that I don't share that concern with Michelle, and I hope that the majority of people out there advocating on behalf of persons convicted are going to be reasonable. I can assure you that it ends up, at least in our office, being much more successful in terms of getting things done as quickly and as appropriately as possible. So I would think when faced with this again, we won't have a problem.
Maybe you could just elaborate, John, because I don't know it's necessarily clear to everybody what you mean by reasonable. I mean, Because people don't always,
All right, wait a minute.
well, people don't always equate me with reasonable, so
I'm afraid I should stop this now because it's going to get ugly quickly. But
31 minutes.
look, the point was made earlier. Obviously, someone who's worn the hat of a defense attorney for 30 years, there is always that duty to the client. I don't want to say above all, but above an awful lot. But I heard the word reasonable a little different, which is not how zealous Michelle or a colleague would be, but how she or you could have the capacity to take a step back and say, I'm going to forget he's my client. Let's analyze this case. Is that the...
Well, yeah, I mean, I actually I didn't mean to, I wasn't trying to be provocative when I said what, I didn't mean that as a criticism. I meant very specifically that in terms of the kind of emotional atmospherics of this, I sort of cautioned myself several times in this process to take a deep breath. And, you know, from the perspective of representing someone in the situation of my client, obviously, I want things to happen as quickly as possible, and therefore that sets in a dynamic. But, you know, being kind of in people's face and unwilling to accommodate the reasonable requests that are associated with how you handle this and how you show some sensitivity to the victim are really not helpful. And I guess that's really what I meant in terms of...
I know. I guess I would hope that in any circumstance, even with somebody who is unreasonable, that we're going to do and strive to do the right thing. But certainly in this case, and I haven't said his name, but his name is very, very public. I mean, if Michelle had gone, you know, immediately to the public and said the prosecutors of Kirk Bloodsworth have done it again, then it's going to get our back up. Because we certainly, I will, to the end of the day, I've been there 22 years and respect everybody that works there, defend our office and our desire to do what's right in all circumstances. But if there had been a frontal attack, you know, out in the media, rather than Michelle picking up the phone and calling our deputy state's attorney and say, I've got an issue that I'd like you to look at, then I guess it's entirely possible that things wouldn't have worked as quickly or as well as they did.
Thank you to our panel.